The nation is on high alert, not because of a single headline, not because of one dramatic courtroom moment, but because of something rarer and more destabilizing. A rapid-fire chain of federal court decisions landing in quick succession, each one slamming the brakes on a different part of Donald Trump's administration. Funding, immigration, energy, offshore wind, humanitarian protections, program after program, policy after policy, suddenly frozen, restrained, or forced back onto the tracks by judges who are effectively saying the same thing in different ways. You can't do this like that, not without a lawful basis, not without the required process, not without evidence. And if you're wondering how we got here, how we reached a moment where court orders are shaping the country's direction day by day, then you have to rewind. Because this isn't just about January 2026. This story has a prelude, a first crack, a warning sign that flashed years earlier, back when the pressure was focused on Trump personally rather than on his administration's policy machine. Go back to June 2023. That month, Trump was indicted in the classified documents case, a major escalation that instantly turned the legal temperature up to maximum. And right after that indictment became public, a second shock followed that many people took as an omen. His legal team in that case began to disintegrate. Two attorneys tied closely to his defense, Jim Trusty and John Rowley, resigned. They left the case, and Trump confirmed they would no longer represent him. That wasn't just a change of counsel. It was a signal that the moment the stakes rose to their highest level, the operation around him shifted, fractured, and had to be rebuilt under fire. That's why the June 2023 shakeup matters now. Not because it proves anything about guilt or innocence, and not because a lawyer leaving automatically tells you the full story behind the scenes, but because it reveals a pattern you can't ignore. Under intense legal pressure, the structure around Trump can change suddenly. Strategies shift. Personnel changes. The situation that looks stable from the outside can become chaotic in a flash. Now, fast forward to January 2026, and the pressure isn't just personal, it's institutional, it's national, and what unfolds is the kind of week that feels like a 24-hour nightmare stretched across multiple days, with courtrooms in different places producing decisions that collide into a single narrative. The judiciary is imposing hard limits, and it is doing it repeatedly. One of the biggest flashpoints is money, specifically money that holds up families, childcare providers, and essential social services. In late January 2026, 5 states, California, Colorado, Illinois, Minnesota, and New York, took the Trump administration to court over a sudden disruption to federal funding linked to childcare subsidies and key social service programs. The fight centered on a major federal agency, the Department of Health and Human Services, and a demand for new documentation that the states argued was impossible to meet on short notice and unlawful in scope. A federal judge stepped in and ruled the administration must temporarily continue funding these programs while the case proceeds. The court's order extended earlier emergency relief, and the practical effect was immediate. The money had to keep flowing for now. These programs weren't minor line items. The reporting described them as collectively providing more than $10 billion annually to low-income families across those states, through channels such as the Childcare and Development Fund, Temporary Assistance for Needy Families, and the Social Services Block Grant. The administration said its demands were connected to compliance and fraud concerns. The states argued the requirements were overbroad, politically motivated, and functionally operated like a funding freeze because funds were inaccessible until court intervention forced a change. This is the kind of dispute that, at first glance, can sound technical: documentation, compliance, agency authority. But on the ground, it translates into something brutally simple. Do child care centers know they can keep staff? Do parents know their assistance will continue? Do social service providers have the funding they rely on to operate next week? When the flow of federal money is interrupted, uncertainty becomes its own form of damage, and that's why courts often treat these cases as emergencies. Judges don't necessarily decide the entire dispute in one moment. but they can order the parties to hold the line while the legal questions are fully litigated. So when people say the administration got hammered, what they're reacting to is the speed and the stakes. The funding fight wasn't just a policy disagreement, it was a federal judge stepping in and ordering continuity, at least for now, because the legal basis for disruption was being challenged. And once that door opens, once courts start stepping in, other lawsuits don't wait. They surge, they stack, they accelerate. That's when the story shifts from a single case into a broader wave. The next front is speech and immigration, where the legal terrain is especially explosive because it involves constitutional rights and because the consequences are so severe. In January 2026, a federal judge in Boston, U.S. District Judge William Young, issued a warning tied to a First Amendment case involving allegations that non-citizen plaintiffs associated with pro-Palestinian activism were being targeted for detention or deportation due to their political views. The case is tied to academic organizations and academics, and it sits on one of the most combustible fault lines in American law: whether the government can use immigration tools in a way that punishes or chills protected speech. Judge Young's message was sharp. He warned the administration against retaliating by changing the immigration status of non-citizen plaintiffs involved in the litigation. He also signaled that certain immigration status changes, if applied to qualifying members tied to the case while it proceeds, could be presumed retaliatory unless the government could prove otherwise. In other words, the court wasn't simply saying, "We'll see what happens." It was saying, "We are watching this closely, and if you move in a way that appears retaliatory, you may be stopped." That's a big deal, because immigration enforcement is one of the strongest tools any administration holds. It can be fast, it can be punitive, it can reshape a person's entire life. And when a judge begins framing the question through a First Amendment lens, it raises the stakes beyond ordinary policy disputes. It suggests the court is considering not only whether the administration is following immigration statutes, but whether it is using immigration power in a way that violates the Constitution's protection of speech and political expression. This is where the narrative becomes what some people call a quiet revolution. Not because it's a revolution in the street, but because it's a revolution in procedure, in legal boundaries, in what power is allowed to do moment to moment. Court orders don't arrive with sirens. They arrive with signatures, with legal standards, with consequences that land quietly and then spread everywhere. And then comes energy, another arena where the administration ran into a wall. A major clean energy funding fight erupted over billions of dollars in grants and financing. A federal judge ruled the administration acted illegally when it canceled roughly $7.6 billion in clean energy grants for projects, pushing the funding back into motion. The legal rationale, as described in reporting, involved administrative law principles that sound dry but hit hard. Agencies must follow lawful procedures, provide reasoned explanations, and comply with how Congress set programs up. If the government tries to cancel or suspend funding without meeting those requirements, courts can block it. This matters because energy policy is not just political symbolism. It's infrastructure, jobs, construction schedules, long-term investment, and industrial planning. When billions in clean energy support are paused or canceled, it sends a shock through markets, through contractors, through state-level planning. And when a judge orders the funding restored or rules the cancellation unlawful, it doesn't just embarrass the administration. It forces a real operational change. Projects that were bracing for collapse can start moving again. States that were staring at a hole in their budgets can breathe again. The legal fight continues, but the immediate outcome changes today's reality. Then, offshore wind becomes another battlefield, and one that illustrates how quickly legal intervention can flip the direction of massive industrial projects. In January 2026, reporting described how the administration had paused offshore wind activity in federal waters, citing national security concerns linked to radar interference raised by the Defense Department. This pause threatened projects that are time-sensitive, partly because of specialized construction vessels and narrow weather windows. A federal judge allowed Equinor, the Norwegian developer, to resume work on New York's Empire Wind project, citing the risk of irreparable harm and the possibility that delays could jeopardize the project's viability. Equinor had already invested billions and reported significant completion progress. Around the same time, another judge cleared the Danish company to resume work on the Revolution Wind project after similar stop-work actions. The effect was immediate. Projects the administration tried to halt were suddenly back in motion because courts determined the legal standards for stopping them had not been met, or that the balance of harms favored allowing work to continue while the case is reviewed. Think about what that means in concrete terms. This is not a symbolic policy memo. This is cranes, ships, crews, contracts, and multi-billion-dollar commitments. The administration hits the brakes, and the courts come in and release them. That's why the word barrage sticks. Not because every ruling is final, but because the pattern is relentless. The administration attempts a sweeping move, and a court order arrives to restrain it. Now, it's important to be precise here. These aren't all final verdicts. Many are temporary restraining orders or preliminary injunctions. They can be appealed. Higher courts can modify or overturn them. But temporary does not mean trivial. Temporary orders shape real life. They force agencies to act differently today. They decide what happens while the legal battle is still alive. And in politics, time is power. And then, the story reaches the point where the legal tremors aren't just about funding streams and projects. They are about people's legal status, thousands of lives in limbo. On January 25, 2026, a federal judge issued a preliminary injunction blocking the Trump administration's attempt to terminate the legal status of more than 8,400 migrants from multiple Latin American countries who had been granted humanitarian parole under family reunification programs. These programs, according to reporting, allowed U.S. citizens and lawful permanent residents to sponsor family members who were waiting abroad for immigrant visas, giving them a lawful pathway to enter and remain temporarily while the system processed. The administration argued the programs were inconsistent with new immigration priorities and prone to misuse, and it moved to end them on a rapid timetable. The judge found the agency's action lacked a reasoned explanation and appeared arbitrary, particularly given the profound impact on people who had already uprooted their lives based on the program's promises. That phrase, lacked a reasoned explanation, isn't just legal jargon. It's one of the most powerful tools courts have for policing executive action. In administrative law, agencies can't simply do whatever they want because they want it. They must justify major changes with evidence, reasoning, and compliance with statutory requirements. If they fail that test, courts can stop them, not necessarily forever, but long enough to force the government back into lawful lanes. And this injunction didn't land in isolation. It arrived amid broader battles over the administration's efforts to roll back parole protections. The same judge, according to reporting, had previously blocked a similar termination affecting far more people, though a higher court later overturned that earlier ruling. That history matters because it shows how these battles can swing, how a win in one courtroom can be challenged, appealed, and reversed later. It also shows how persistent the litigation is. Each time the administration moves, lawsuits follow, and courts are asked to intervene again. At the same time, another major immigration fight surged into the spotlight: temporary protected status, known as TPS. TPS is a humanitarian designation granted to people from countries experiencing extraordinary conditions, armed conflict, environmental disaster, or other crises that make returning unsafe. It doesn't create citizenship. It doesn't automatically create permanent residency, but it does provide temporary protection from deportation and work authorization. In January 2026, immigrant rights advocates filed a lawsuit in Boston federal court seeking to block the administration's decision to end TPS for Ethiopians living in the United States. The lawsuit challenged the process and rationale behind the termination, alleging the Department of Homeland Security failed to properly assess country conditions and did not follow legal requirements. The plaintiffs argued that unsafe conditions persisted, including conflict in regions of Ethiopia, and that the administration's move was improperly motivated. The administration argued TPS had been misused as a path to longer-term residency, and that conditions no longer warranted continued designation. This is the kind of fight that turns into a high-stakes legal tug-of-war, because it isn't just about a policy preference. It's about whether the government complied with the law in reaching its decision, and what evidence supports it. And this wasn't just about Ethiopia. Around the same period, Reuters reported a judge delayed the planned termination of TPS for migrants from Myanmar, criticizing the stated rationale and setting hearings while blocking the immediate cutoff. Again, you see the same pattern. The administration moves to end protections, and courts scrutinize whether the move is justified and lawful. Now, take a step back and look at the whole picture, because this is where the narrative becomes explosive. First, you have the earlier warning sign in 2023, a high-pressure indictment and a sudden shakeup in legal defense, indicating that when pressure rises, things around Trump can change fast. Then you have January 2026, not one court fight, but multiple. A judge ordering continued funding for childcare subsidies and social services in 5 states, pushing back against a disruption tied to new federal demands. A federal judge warning the administration against immigration status retaliation in a First Amendment case tied to pro-Palestinian activism. A clean energy funding cancellation ruled unlawful, forcing billions back into motion. Offshore wind projects released to continue after stop-work actions because courts weighed the legal standards and the harms. And immigration protections, humanitarian parole statuses, and TPS designations being challenged in courtrooms where judges are asking, did the government follow the law? Did it provide a reasoned explanation? Did it respect constitutional limits? This is why people are calling it a legal earthquake. Not because the administration loses every case forever, and not because the judiciary is taking over, but because the judicial branch is doing what it was designed to do, checking executive action, demanding lawful processes, enforcing constitutional boundaries, and forcing the government to justify itself. To supporters of the administration, these rulings can look like judicial interference, like courts preventing elected leaders from implementing their agenda. To critics of the administration, the rulings look like accountability, like judges stopping overreach and protecting rights. But regardless of which political camp you're in, the practical reality is the same. Court orders are shaping what can happen right now. They are deciding whether money flows today, whether projects proceed today, whether people can keep their legal status today. And that changes everything. It changes the pace of governance. It turns policy into litigation. It forces agencies to move slower, to document more, to justify more, to anticipate lawsuits at every step. It changes how states respond, because once they see courts are receptive, they file faster and harder. It changes how advocacy groups respond, because injunctions prove that courts can intervene before harm becomes permanent. It changes the political messaging, because each new ruling becomes a headline, and each headline becomes a weapon. And perhaps most importantly, it changes the administration's capacity to project inevitability. When an administration wants to appear unstoppable, it moves fast and makes its agenda look like a steamroller. But a steamroller that keeps hitting court-ordered barriers starts to look less like a force of nature and more like a machine that can be stalled. That's why the language of collapse and ruin spreads online. It's not that the administration is literally destroyed, it's that the image of total control, total dominance, starts to crack when judges repeatedly intervene. Still, it's crucial to keep your footing in reality, because the next stage of this story is not a single final moment. It's a long legal war. The administration can appeal many of these rulings. It can revise policies to meet legal standards and try again. It can gather evidence, issue new explanations, adjust procedures. Meanwhile, plaintiffs can keep filing new cases, seeking new injunctions, pushing courts to expand orders. Higher courts can narrow or overturn rulings. A win today can become a loss tomorrow, and a loss today can become a win later. This is why the legal system can feel like an endless battlefield. It doesn't always end with a single knockout punch. Sometimes it ends with exhaustion, with time, with the slow accumulation of precedent and procedure. But even in that uncertainty, the immediate impact of these January 2026 decisions is undeniable. Families in those 5 states keep receiving support while litigation continues. Energy projects keep moving while courts review the government's actions. Offshore wind construction resumes while the merits are argued. Non-citizen plaintiffs in a First Amendment case are placed under the protective shadow of a judge warning against retaliation. Thousands of migrants retain legal status for now because a preliminary injunction blocks termination, forcing the government back to the drawing board. So, what does it mean for the future of the country? It means the next phase of governance may be defined less by what the administration announces and more by what courts allow to stand. It means policy fights will increasingly be fought in legal briefs, in injunction hearings, in emergency motions. It means state attorneys general, advocacy groups, and industries affected by abrupt changes will keep racing to courthouse doors. It means the administration's ability to move quickly will depend on how carefully it builds legal foundations, documentation, reasoning, evidence, adherence to statutes, before it acts. And it raises a question that cuts deeper than any single case. What happens when the judiciary becomes the primary brake on executive ambition across multiple fronts at once? Some will call it dysfunction. Some will call it checks and balances working exactly as intended. Some will call it a sign of a system under stress. But one thing is certain, this is a defining moment in how power is contested in the United States. Not with tanks, not with street battles, but with injunctions, statutory interpretation, constitutional claims, and administrative law. And as this legal earthquake continues to rumble, appeal by appeal, ruling by ruling, the country is left staring at the same central question. Is this the beginning of the end for Trump's current agenda, as courts dismantle it piece by piece in real time? Or is it simply the opening act of a longer confrontation, where the administration adapts, appeals, and returns with revised strategies designed to survive judicial scrutiny? Either way, the message of this moment is unmistakable. The courts are not watching from the sidelines. They are acting. They are intervening. They are shaping outcomes. And they are doing it in a way that forces the entire country to confront a basic, uncomfortable truth about American power. In the end, it isn't only politics that decides what happens. It's law.